Yes, so the accountants and the lawyers sent to me the proposal that the husband and wife had both made in regards to superannuation. So I did an evaluation of what the net cost was and effectively just said, well, I'd be taking the wife's offer. And the husband says, why is that? And I said, well, you're paying a 500 grand less than what your offer is. So he went, okay, deal's done. And the accountant said, how come it was so simple? I said, well, generally because you guys can't see the wood for the trees. You're too engrossed in the deal that you're trying to put together, and you didn't actually look at the offer and analyse the two. I said, so the client was, quite a wealthy, smart businessman. And he went, well, that's pretty simple. We'll take that deal. But that's not a mediation role. That was something I was brought in as an independent expert financial person. But yeah, so often at mediations, it's not so much about going in with an expectation of what we think is a good deal. It's really about trying to get the clients to walk away with something they're happy to live with. Anyway, thanks, John.
Thanks, Brad. Welcome. I'm sorry that I'm late. That will happen from time to time. I do apologise. But, Brad, thank you very much. I caught what you were saying there, and I wholeheartedly agree with your comments. What is interesting is that in the ADR process, there are often many ways in which a matter can be structured. There are many ways that people can participate. And what we have seen increasingly is the use of things like expert conclaves. And I think, Brad, you were sort of alluding to that, where we bring in the experts to provide some advice, provide some opinion work, and a conclave is a specific mediation between the experts. We use that in QCAT. It's also more widely used in other jurisdictions as well. So the assessment that we've got lined up for you this term is similar to the assessment we had last year. And the first assessment is practically the same as the students conducted last year. For the most part, people enjoyed it. I think you'll enjoy it. I want you to have fun with the first assessment. And essentially, your role is to be a mediator or conciliator. And I will assess you only for the online work that you present. I do ask that you supplement that online work with some notes, up to 500 words, just to give me a broad outline of what it is that you're achieving or hope to achieve during that ADR session. The idea of having groups of 3 is that you've then got people that you can bounce off. So you've, as the mediator or conciliator, you've got 2 people that are the participants. You provide them with just some general guidelines, and from that basic guideline, they do their thing and you mediate or conciliate in the middle. That's the aim of the first assessment. I'm going to suggest a few things. The first is that the assessment probably is well suited to a live session where the people are in the same room, but you don't have to be. And many of the people that participated last year conducted their mediation sessions online. And I believe that you can do that just as well as in a live session. So don't be afraid to join up with some people that are in different areas geographically. The other thing is that when you're preparing the work for the assessment, prepare something of a dispute scenario and provide your participants with some guidelines. But please don't script it and don't give them too much information. And ideally, you would provide them with some information that you don't disclose to the other side and vice versa. That way you can get some genuine reactions, you can get some genuine surprise, and you can provide some guidelines. So, for example, it might be that one particular participant is quite difficult, or it might be that both are difficult, or it might be that neither are able to participate and you've got to draw material out. So I'm giving you a bit of a blank canvas here in that you can create a scenario to some degree, but from then you need to allow the actors to do their own thing. Now, I'm interested for thoughts about the use of the word actors. I meant that in the context of the participants, but I'm just going to raise the issue that when you are involved as an ADR practitioner, in many ways you are acting. Now, does anyone wish to comment about that statement that I've just made? Good, bad, indifferent, not relevant, doesn't apply. Any thoughts?
I'll throw something in, John, that I said earlier. Was the purpose of acting is to come in with a preconceived idea as what you think the legal outcome should be, tends to create a bias on the part of the mediator, because you're trying to move parties to a position that you think the outcome should be. So coming in as an actor, you are just basically responding to the feedback by the participants, and you have to be very much engrossed in what the verbal and non-verbal communication is that's going on. So to then be trying to think, oh, as a lawyer, this should be the outcome, makes it hard for you to take on, the verbal and non-verbal communications.
Okay, thank you. So I take it from that, Brad, that you're perhaps proposing that acting skills would be a negative, or the use of acting skills would be a negative in an ADR context. Have I interpreted you correctly there?
Oh, no, because often you mightn't like the people that are there, so you've got to act like you do like them.
Okay. No, that's
a fair comment.
Does anyone else wish to... And the reason I'm raising this right now is that I want you to start thinking of a mindset as to how you're going to approach the first assessment piece. How are you going to do it? Are you going to do it by the book? Are you going to do it as a method actor? Are you going to do it as an actor who scripts the material? How are you going to do it? Are there any other thoughts? And thanks very much for that, Brad. Now, I could start nominating people. Wouldn't that be terrible? But I won't. Does anyone wish to offer any comment? Thanks, Gordon.
John, I did professional conduct last term, and we did a similar thing using Zoom, but we were actually given the scenario, and the two others in the triplet were one person was the observer, and the other two were the protagonist and antagonist. So the observer wrote up their evaluation of how the lawyer and the client were interacting. What do you think of that?
Yes, that's a good option. Does anyone have any thoughts about what Gordon has proposed? In ADR talk, what we're doing now is we're fact-finding. We're getting some ideas from across the room. Thanks, Gordon. And Michelle, I think you were thinking along the same lines.
Yes, yeah, I did that assignment as well, and I really liked it. And I think what you say about not overly scripting your actors, as in your clients or your parties, really leads into, and I can remember how that assignment was written. And basically it was, this party one, these are the person's issues, this is what their character's like, this is the kind of feel you get from them. And then you've really got to wait and see what they present like and basically run from there. So I can see that this assignment's going to be very similar to that kind of thing. It's just that we can draft our own sort of terms or people or whatever the case may be.
Okay, thank you, Michelle. I'm going to propose two things for you to consider, and I'd like your feedback on this. The first is that the role of a mediator or conciliator, in essence, may result in the conciliator or mediator becoming the new best friend for the participants. So I'll put that out there as a statement. And the second thing that I want you to consider is this, that this is not your dispute as the mediator or conciliator. It's not the lawyer's dispute. This is the dispute of the participants. So does anyone wish to comment about those two statements that I've made? Please feel free to disagree. And I can start nominating people if you want.
I was thinking the main difference with mediation is like when you're a lawyer, you act for a particular party, so you're looking for the arguments that suit their side of things, and you very much take their side of things. Whereas with the mediator role, you have to step right back and try and find a solution rather than try and win.
That's a very good point. Thank you, Kylie. Does anyone else wish to make a comment about what Kylie has said? I agree with what Kylie said. Or make any other comments? Let's deal with that first issue. You may end up becoming the participant's new best friend. What's that all about?
Is it that you can help them achieve something that they didn't really think was achievable in the circumstances, or I guess finding solutions to their problems that may not have been obvious to them?
Yes, I think that's part of it.
John, perhaps you're referring to at some stage you're going to bring some sort of closure to the matter.
Yeah, and that's something that people do like. It's their dispute, but generally people do like to have some closure. Thank you for that contribution, Jason. Does anyone disagree with me? Does anyone say that, no, if you, as a mediator or conciliator, if you end up being the party's new best friend, you have failed in your purpose?
I would say that a mediator is supposed to remain neutral. So in that sense, I don't think there's really a place for a mediator or conciliator to be a party's best friend. They would need to be treating both parties equally. And if they weren't, well, they wouldn't be doing their job effectively.
Is it possible to remain completely impartial, to not exhibit bias, but essentially become popular with the parties? Is that a good, ideal situation, or is it impossible? Is it something we shouldn't aspire to do?
I think that you could show empathy to both parties and show good communication skills and things like that, and that would be okay, while remaining impartial at the same time. Okay. So in that sense, you could be popular, I suppose, because I suppose the parties would be feeling like they were being heard.
No, thanks, Deb. I appreciate that comment. What do you think, Bronnie?
I think that, you know, you need to consider each party's, listen to both parties' side of the argument in the beginning, and then you can make a considered determination of what would be the best outcome for both parties. So you have to sort of take it listen carefully to both parties.
Love that word listening in the context of ADR practice. And I see Brad's nodding approval there. Active listening is so important in the context. And can I ask you this? Now, Grace, I might even call on you for a comment here. But if someone is listening to you, how does that make you feel?
Sorry, I'm not sure if I'm unmuted. Yes, I am now. I think it's very rewarding when the parties are listening to the mediator or conciliator. The problem I would see only is how much both parties are cooperative and they really want to achieve an outcome, good outcome. If one party wants to mediate, but the other party is reluctant or does not want to mediate, and it's basically difficult in the whole process of mediation. Sometimes it's very difficult, and I think, to bring those parties together that they both want to mediate and have a closure on a whole problem.
Okay, no, thank you very much for that. So I would like you to think about that, and I'm trying to put this in a neutral sense, although you can probably tell from my enthusiasm for certain the way I'm putting this that I have a view and that view is that it is possible, entirely possible, to essentially become the new best friend of the participants during that mediation process. One way that can occur is through active listening throughout, but also we see that dynamic very clearly, and I'll be interested in your thoughts on this, Brad. We see that dynamic very clearly when it comes to the private sessions that a mediator or conciliator will generally conduct with the parties. Does anyone, Brad, or anyone else wish to comment about the way in which the private sessions may have a dynamic on the relationship between the mediator and the participant?
John, one thing that you did say is, and I often say to clients, is everyone wants to be my best friend. So they're all trying to make themselves look like the good guy. In private sessions, I find the best results in mediations have both parties there. It's fine to break out and have a private session. But yeah, they're still trying to push their point. And the role of the mediator is not to sort of agree with their view. It's really to, I find when I do a private breakout, is to drill down on what do you really mean by that. And if they're not prepared to accept that, what do you think your alternative would be? Because I always say, when you're trying to sell something, if you only give them one option, they're going to say yes or no. If you give them two options, they'll go, well, I like that bit and I like the bit in option B and I like the bit in option A. Well, if we could then use that bit in option A and that bit in option B, would you be happy with that? So, yeah, it really is about drilling down on what they're saying to us to really create an alternative for the one person. So when you go back to the other party, you've got two options to work by, because if it's not the one that they agree and you only gave them one choice, they'll either say yes or no, or they'll come back with their ridiculous alternative proposal. And so it's really hard. You're just going backwards, forwards, and you're not really drilling down on that problem.
But what if your choice or recommendation that you've presented is not even close to what both parties are seeking? What do you do then? Like you've come up with a statement that says, okay, well, you know, hypothetically they're arguing about ownership of the dog. We'll use a dog rather than a cat because of our previous conversation. Let's say, for example, they're arguing about the ownership of the dog, and then you say, well, you know, one of you should get the dog, and by the way, here you have a bottle of wine as well to make up for it. You know, it's not really what they're arguing about. Is it right to present that extra option?
Look, I'll leave this to John, but my view on it is you're breaking it down. So I have often people say, I don't like this or I want this. And I'll say, so what don't you like? On what you don't agree on, what parts of that do you agree on, and what parts of it don't you agree on? And so you just keep breaking it down and breaking it down and breaking it down until you do get to the crux of what that actual problem is. And then you know that's what I'm trying to resolve. It's not about the dog or the bottle of wine. It may be something completely different. So you've got to keep breaking it down. So delivering, just, you know, I often see mediators when I'm there as a participant, just delivering messages backwards and forwards. And you think this is ridiculous. It's going to go nowhere because everyone's just, until someone delivers back what the other person wants, you're getting nowhere. That's my view anyway.
So there are a few words that come to my mind as a reaction, if you like, to that discussion, which was really good. One is brainstorming. That's a word that comes to my mind. Another word that comes to my mind is options. Another one is reality testing. It's really 2 words, I guess, but I'll hyphenate it to say it's 1. So there's, if you like, 3 words that come to mind, and there is a concept that goes with it. And that concept that goes with it, to me, is ensuring that the parties are aware that this is their dispute and you're there to assist them in that role. Now, does anyone wish to make any comment about those things that I have just said? Melissa, would you like to weigh in here with some comments in relation to those words in the context of a private session, if you don't mind if I call on you?
Yeah, that's okay. I was just thinking that if you become friendly in a way with the parties, they will be more comfortable. And when you get into a private session, they're not going to kind of have their guard up. They're going to relax a little, and they're going to feel that they can really tell you what it is they're trying to achieve, which then gives you a better insight into options you might be able to put forward when the parties are back together, or give them things to think about that maybe they haven't thought about, because you're getting a better insight into what it is they're looking for.
No, that's great. No, I totally agree with that. Why do you think that I've mentioned a couple of times that as a mediator or conciliator, you need to bear in mind this is the party's dispute? What's the relevance of that? Would either perhaps Peter or Ian like to make any comments about that?
Yeah, I can just to give my thoughts. Yeah, it's their dispute. I mean, it's their issue that they have to be happy with the solution. That you're just helping them get there. So, I mean, whatever it is that they've got to sort out, you're just facilitating the outcome. So, I mean, you have to allow them to be happy with the outcome. Well, they might not be happy with the outcome, but you have to allow them to choose the outcome, and it's not for you to sort of like determine what that should be for them. It's for you to help them get there.
Yeah, thanks, Peter. And I guess part of that role of helping them to get there means being very clear about what is your role. Does anyone have any thoughts about the essential difference between a mediator and a conciliator in terms of the advisory function? Does anyone wish to make any comment about that? You may have read ahead to do your reading. The difference between conciliators and mediators in the context of the advisory function. Yes, Grace?
Mediators, I understand, are the people who are basically facilitating the conversation between the two parties, whereas the conciliators, they are helping with an advice. They are giving hints and advising people in which direction they should be going. So they are more involved probably in the whole process in a way that they guiding the couple or the people, the parties, in which direction they should go.
I agree with that. Does anyone have any further comments about the role of a mediator versus the role of a conciliator in that context? And thank you, Grace. All right. Look, I haven't heard from Ian, and let's see, Peter Ferrick is there as well. I mentioned the word brainstorming before. I mean, what does that mean, do you think? And do you see any reason why a mediator or conciliator should even think about brainstorming? Any thoughts?
Yeah, I mean, the brainstorming, in my experience, is where we sit around with a whiteboard and just throw ideas on the board, and there's no such thing as a bad idea. Anything's open for discussion, and then you go through it one by one, sort of evaluating them afterwards once you've got a whole bunch of ideas on the board. And I think that would be really good in a sort of mediation situation. And you could either, I guess, do it on the private sessions or in the sort of group sessions as well. But yeah, I think brainstorming would be, if you were getting to a point where there were no options or people were just so far apart, then that's probably a good way forward.
Yeah, I agree with everything you've said there, Ian. And if anyone has any comments, but please let us know. Peter Ferrick, if you opened up the parties to a brainstorming session straight away, Do you think that would work, or do you think that that might have some inherent dangers?
Hard to just check where my mic is at the moment. Hard to tell, because I think if you were to do it in the first instance, you could say, well, it gives you lots of ideas. But if part of the idea is to give some guidance as well, you sort of, I would think you miss that opportunity.
Yeah.
That's sort of all I can think of at the moment.
And I'd be interested for someone's thoughts on this. Brad, if I may come back to you, in a mediation session, sometimes, or a conciliation, people are very anxious and there's a lot of emotion running. I guess just to follow on what you've just said, Peter, thank you for that. If you introduce a brainstorming session early, it may backfire on you in that the emotions that there will really vent quickly, and when you ask people to generate all sorts of ideas, the ideas might have something to do with jumping off a bridge or, you know, doing something else, and not a genuine positive brainstorming exercise. Brad, do you think that's right, that you've got to be a bit careful about when you brainstorm?
Yeah, look, the process I use to do that, I do the brainstorming with them in their intake sessions generally a week before the mediation, to be able to talk through the pros and the cons of different options and just, you know, get their views and no views wrong and all those sorts of things. That's really to help plant the seed that at the mediation, if option one isn't working, they've thought about alternative options prior. So in answering your question, two parts to it. One, the mediator controls the speed of a mediation. So I work to a very structured process. So I use lots of weird techniques, like it's like eating an elephant. And they go and they look at me and I go, well, how do you eat an elephant? Piece by piece. So you break everything down into smaller amounts. So there's a thing I learned many years ago in AMP sales training is there's 7 yeses to a sale. So if you break things down, they can go yes, yes, no. Oh, okay, well, let's work on that no bit. What's an alternative to that? So that way the mediator is controlling the speed. The anxiety is generally generated from the client's expectation of trying to get to a point quickly. So, you know, they're things that I often feed back to them early. This is not a race. You know, work our way through step by step. So, but yeah, brainstorming, can, you know, the training I've had said give people the chance to have an opening statement and let them vent. Well, I don't let people vent. I go, it'll take me an hour to get everyone back on track again. So brainstorming or venting can really start you off on a really bad point and take you a long time to get everyone's anxiety and anger and levels back to a point where you can actually negotiate. So I tend not to use that training I had at Bond, because I did early and found it was exactly what you're saying. The brainstorming and letting people vent got people, because one person is not actually listening to the other person, they're thinking about how they're going to rebut that.
Yeah, and
So
look, I agree with most of what you say. I adopt a slightly different technique. Certainly it's apparent from what I've hinted that I think brainstorming is a great technique, but there's a time for brainstorming, and in my view, you can bring it in too early. If you bring it in too early, it'll backfire on you. A thing that Brad mentioned, I think, is really worth picking up on, and that's this concept of venting. Venting is essentially where, to some degree, the mediator or conciliator allows the parties to have their say in a relatively unrestrained manner, typically at the start. And rather than allowing the parties to go at each other, sometimes it's a useful technique, I think, to allow them to vent What that means is have their say, have their little mini explosion, but directed at me. Come look at me at that stage while you're doing that. And at the same time that you're allowing the party to vent and you're soaking that emotion and you're soaking up that difficulty, you are using your body language to keep the other side on side. And often, you can't quite see my hands, but oftentimes I'm actually physically using my hands as a reassuring mechanism to the other side while I'm maintaining eye contact directly with the party that's venting. And the contact, what I'm doing is saying to the other party, look, I know you're here, I know you disagree, bear with me though, let me soak this up and we'll then be able to move on. Quite often the other party will want to vent, but you want them to go one at a time. You soak up both parties. It's directed to you at that early stage. They've had their say. All right. Now, let's see if we can work on just finding out the real issues here and generating some options so that we can move forward. You've had your say, but let's move on. So in that sense, I do allow some venting. Brad doesn't. And really, that's an interesting point because, and I'm going to bring in, I'm going with some alliteration here. Mercy, Molly and Michelle. Hi. What I want to do is just seek your comment, if I may, about something that Brad mentioned that I think is really important, and that is the word control. So to what extent do you think a mediator or conciliator should take and maintain control?
I think it's as much as necessary for the particular parties. So I think that's not something that you can have certain. I think in your bag of tricks, you need to be malleable and you need to be able to read the people. Yeah, I don't think I could be more precise.
Thanks, Michelle. Mercy?
I think it's when one or the other party gets abusive, that's when I would say something or halt and have time out. I think it's easy to do that when you're so emotional and, you know, it can get harassing, it can get abusive and it can get out of control. So you have to control that atmosphere by letting them, you know, have maybe some time out.
I think that's important. Yep.
Sorry, John, if I could interrupt there. I think your point about letting people vent is very important, because if people don't feel like they've had their say, you're not going to be able to bring them round to another suggestion or some sort of, you know, a goal that you're trying to achieve, because quite often people just want to get their point across for whatever reason. They've never had the chance to, and they want somebody else to feel their pain and understand what they're going through. So I believe if you let them do that in a controlled environment like that was mentioned, you can probably achieve a faster result, but you just can't let it go too far. And I think as soon as it gets too personal or abusive, at that point there, you have to stop it, time out, then come back to maybe. That's just my thoughts.
No, thank you, Jason. And I'll come back to Brad shortly. But before I do, Molly, you don't have to say anything, but is there anything you wish to add to the discussion?
No, I'm fine, thank you.
Thanks, Molly. Now, Brad, you've correctly made the point that you're talking about controlling the speed, not the individuals. You do venting at a different time at the intake stage. Does anyone wish to make any comment about controlling the process throughout the process? And if so, how do we reconcile that with my earlier statement that this is the party's dispute, it's not your dispute? How do we reconcile that?
I think the process is the domain of the mediator. And so in order to keep the people on track and focused on the issue, it is the mediator that is in control.
Okay. How do you feel about that, Brad?
Yeah, I'd like to work to a structure, but this is one thing that I use. when people are venting. So because as the mediator, the less talking we can do, the better. But so I advise them at the beginning that if either of you are disrespectful to each other, the process, your children, or to me, I won't say anything. All I'll do is I'll just hold that up, meaning I heard what you said and you're not being very respectful, because that's 17% of comprehension, whereas if I said anything, it's only 7%. So I almost triple my comprehension intake by the other party. And, you can then put your hand on the red one if anyone's getting way too out of control. So I've only ever used that once, and it was with a police officer over domestic violence. So in 500 mediation. So it's funny, when I first did it, the wife's giving the husband a bit of a spray, and I was doing, as you said, I'm just saying, okay, let's just let this get out, let it get out, let it get out, let it get out. And the husband looked at me and went, Brad, don't you think that's worth a yellow card? So it's a bit like, when the footy players are on the field and they say, hey, ref, he's offside. And so it removes that, backwards, forward. So it's a technique that works for me. People will find something that works for them. But yeah, so I hope that answers your question. Sort of just having a structure and then controlling that speed and that process, and listening, taking lots of notes, because people will talk around and around and around in circles, and they'll say one thing and then they'll say something completely to the opposite. And you think, hang on a sec, you said this, now you're saying this. Hang on, I'm getting lost. And
yeah, no, I agree with what you're saying there, Brad. Thank you very much. And I guess we've got to be careful about allowing things to become circular, and we've got to maintain some control over that process and do it carefully. Ricky, I'm going to bring you in at this stage. We were talking about brainstorming, and you've raised a very good point, and that is the word issues. And I just wonder if I could ask you to elaborate on that and talk about the importance of identifying the real issues.
Yeah, sorry, I don't know what to say other than brainstorming too early before you have the issues. You're going to bring up other issues that probably aren't that significant. We need to really, right from the onset, identify what are the issues in dispute. Otherwise, all the other crap will come into it and we're just wasting everyone's time. That's what I was thinking.
No, I agree with that. And I think it's really important at the outset. Well, there's so many things at the outset. So far, I've said there's 10 things that you've got to do at the outset. But at an early stage, you need to identify the issues. Does anyone have a word for me that we can use to contrast the word issues? Issues versus something else that people normally pursue. This is a very cryptic question. The word I'm looking for starts with P. There's actually a couple of words that start with P. So we have to take people away from their P and get them thinking about the issues. Melissa, what do you think?
I'd say their positions.
Yeah, that's good. We've got some other very good responses, problems and points, but I really like the pain. I really like the word position. So what do we mean by position, and how do we contrast that with the word issues? What's the difference, do you think?
Do you mean position is, sorry, Ricky, a particular point of where somebody stands as opposed to an issue is who gets the microwave, so to speak?
I think isn't it a bit more kind of like issue sounds kind of negative, and it puts that view on it, whereas if it's your position, it doesn't sound like such a negative stance to start with.
And it's funny but it might be my training, but I think the other way around, in the sense that, how do I put this? As a litigator, people come to me and they say, look, my position is I want $1 million. Or, you know, it's the principle of the thing. That's the other P word that kind of gets to me a little bit. People say, well, I want to sue for the principle, or that's my position on whereas what I try to do, and it's a little different to what you were saying, Melissa, is I try to work them around, that is the parties, towards thinking about their real issues, or there's another I word that I really like, and it's their interests. So what are their interests? What is in your real interest? It might be this is your position. Your position is I want $1 million, but is your interest to have, I don't know, happiness in your life, things of that nature. So just think about those words, because I want you to start developing your own terminology that works for you, that you can explain to people in a mediation context, and that you can be very clear that you're working towards during that mediation or conciliation session. So thank you very much for that. Kath and Kim have issues. That's a good point as well. So probably more so than issues, to take up on what you've just said, Melissa, maybe if I could say interests. Let's use that as what I think is an optimal word to use, as opposed to their positions or principles. Now, I'm very conscious that we've lost a few people to another tutorial. It's very hard. In 4 nights, we've got, you know, Monday through Thursday. I was originally a Monday person and a Tuesday. I've now gone to Thursday because it's the least crowded in terms of the law faculty, but there are still some clashes. So we've lost a few students already, but we are taping this.
John, just remember, we're law students. We could probably do it on a Saturday night because we've got nothing better to do.
I'm available Saturday night. I'll be ready to go. That'll be good. Somehow I think, Jason, that's not entirely correct for everyone, but thank you for that. All right. I'm not sure that we should take it any further tonight, but I really wanted, as this introductory session, to do 2 things. Firstly, apologise for my tardiness. I'm sorry, but I'm so pleased that that you started to engage and discuss things, and maybe that will be my ploy in ADR in the future. I'll just intentionally come in late so you start discussing things amongst yourself. Thanks very much, Brad, for your contribution in that regard. And we will meet at 6 o'clock next week. Please use UCrew primarily as the forum for discussions. I guess it's just my preference to use UCrew rather than Moodle, but anything that gets us talking is a great thing. Think about your style for the mediation or conciliation, and let me know your groups, and I'll add them on the front page of Moodle so we know who's working with who. And the other thing is that it doesn't have to be a university student in this class, or it can be anyone, is, you know, to play the parts. The main thing is that you're the mediator or the conciliator. All right, so before I wrap it up, are there any questions before we go? All good? No comments? Okay. Well, I'll stop recording now and we'll see you all next week. Thank you. Bye.